provides a guaranteed remedy for the enforcement of those rights, and this remedial right is itself made a fundamental right by being included in Part 3. This court is thus constituted the protector and guarantor of fundamental rights, and it cannot, consistently with the responsibility so laid upon, refuse to entertain applications seeking protection against infringement of such rights. No similar provision is to be found in the Constitution of United States, etc. Lord, here the officers are also before your lordship seeking their Article 21 rights, because there are FIRs filed by the local police, and they are threatened with, my lord, their freedom under Article 21. Apart from, my lord, my lord, jurisdiction, my lord, on behalf of the victims of money laundering, my learned friend.
Kindly have a look at Article 226, sub-article 4.
226.
226, sub-article 4. The power.
Yes.
The power conferred on a High Court by this article shall not be in derogation of the power conferred on the Supreme Court by Clause 2 of under Article 32. So this, according to me, is the issue. 32 powers are protected even under 226, as by the Senior Solicitor General had said, it itself is a fundamental right. There have been cases where your lordships have transferred investigation to the CBI in exercise of powers under Article 32. I may give one or two judgments by way of illustration. I see. Kindly have a look at para 80. And 82.
80.
80. This has been done in exercise of powers under 82. I may just leave it. But in a given case, your lordships may come to a conclusion that it warrants not only investigation by the CBI, but it warrants investigation to be done outside the state. In a given case, if it is to be done outside the state, 226 powers cannot be exercised. One judgment, my lord, to para 89. All that. I leave it to that extent. Therefore, now as far as the
Yes.
ED officials are concerned, my lord, 4 FIRs have been filed against them. Kindly have a look at section 67 of the Prevention of Money Laundering.
Which provision?
67. No suit
Yes.
shall be brought in any civil court to set aside, modify any proceedings or order made under this act, and no prosecution, suit or other proceedings shall lie against the government or any officer of the government for anything done or intended to be done in good faith under this act. So the search proceedings were done under good faith under this act. Therefore, the prosecution, the FIRs are not maintainable. They're hit by the bar under 67. Despite that, to put pressure on us, these 4 proceedings have been filed. Therefore, I have read separately for stay. Order of stay may be passed, notice may be issued, and the matters may be heard. This is all that I was.
We are praying for stay of the FIR against us. The ED officials are facing FIR filed by the local police. These are the FIRs. We have made the averments, we have given the details, and we have prayed in prayer F.
Yes.
And they are constantly filing new FIR. So that has been a pattern we have seen. So page 126 is the prayer clause.
Let us see the prayer. Prayer is
Page 126. Page 126.
No.
E. Capital.
Main matter, page 46.
126. Main relief. Yes. Issue a writ of mandamus directing the. Your Lordship wants the entire prayer clause to be read, or
Just a minute.
Or the interim.
What are your, yes, interim.
Interim is page 126. But where right now, my lord, I would be subject to your Lordship's being persuaded, praying for E. In the meanwhile, your Lordship gets direct stay of the FIR number so and so registered at Shakespeare Sarni, FIR number so and so, and any other FIR registered against any officer of the Enforcement Directorate with respect to the searches conducted on 8/1/26 during the course of investigation of coal scam, etc. So we have restricted our prayer to this incident.
This pass interim direction commanding the respondents to preserve, deposit, and provide a CCTV camera, this too.
Yes, my lord, that should be preserved, my lord. Let it be with the registrar of this court.
No, right now you are praying for E only.
E. But my lord, if my lord, your lordships are persuaded, my lord, C also, my lord, A. Interim directions commanding the respondent to preserve, deposit and provide the CCTV cameras and storage devices containing the footage of both the premises search on 8/1/26 as described, and not to make any deletion.
Just take. In these two writ petitions, referred by the Directorate of Enforcement. Oh, yes, in the first writ petition, the petitioners are Directorate of Enforcement and its Deputy Director. Whereas in the second writ petition, the petitioners are
They are the assistant directors and the persons who are named party to the search, and they've been named in the FIR as
the officers of the Enforcement Directorate.
One is the IO of the
Enforcement Directorate, against whom
nobody is named. I'm sorry, nobody is named.
Huh?
No, they are not named, but they would be.
They went for the search, and the officers who conducted search without naming them are the FIR.
Who had gone to the premises, subject premises, in course of investigation conducted by the ED. Learned ESG, appearing for the petitioners, would draw our attention to the series of events which has led to the filing of the present writ petition. According to him, the ED was investigating a scam amounting to rupees 2,742.32 crores since the year 2020, and in course of the investigation of the said scam, intelligence was received that about 20 crore of proceeds of crime from Kolkata to Goa was transferred through R. Kantilal firm, and which has eventually channeled into I-PAC's operational framework by being handed over to persons executing its work. Armed with authorization to carry out search and seizure proceedings at the residential premises of Mr. Pratik Jain of I-PAC, the officers visited his premises on 8/1/2026. Visited his premises, amongst other premises, on 8/1/26. And when the search was going on, the Manoj Kumar Verma IPS, the Commissioner of Police Kolkata, first entered the premises. Dr. Sri Priyabrato, IPS Deputy Commissioner of Police, Sri Manoj Kumar Verma, IPS Commissioner of Police Kolkata, entered the premises, and thereafter the second respondent in WP number so and so, the sitting Honorable Chief Minister of West Bengal, Ms. Mamata Banerjee, also entered the premises despite making categorical request for not interfering with the ongoing search proceedings under PMLA. He would submit that this is not the singular incident where Honorable Chief Minister has entered the premises under investigation by the ED, under investigation, as on an earlier occasion when the CBI was investigating an offense, the similar event has happened. Therefore, there is a pattern of interference with the investigation carried on by the central agencies. According to him, the materials collected by the ED officers were taken away by the respondents in an illegal manner. And thereafter, the West Bengal police have registered FIRs against the officers of the Enforcement Directorate. Lord SJ would submit that in a situation like this, it is difficult for the central agencies to carry on investigation which has connection with a huge scam running into so and so, 2,700 so and so crores. Learned Counsel would submit that true it is that the petitioner ED has prepared a writ petition before the Calcutta High Court, but when the matter was to be taken up for a hearing on 9/1/2026, the legal cell of the Trinamool Congress sent message to its member on WhatsApp calling them to assemble in the court. And thereafter, what has happened in court has been recorded by the learned judge in its proceedings dated
page 121. 121. Order is
dated 121, which is reproduced hereunder. Para. On the above basis, Learned Counsel would submit that Learned SJ would submit, firstly, that the present is a serious matter which needs to be examined by this court, and secondly, the High Court is not allowed to proceed further. According to him, since high police officials of the state government are involved, it would be appropriate for this court to examine the issue in the larger interest of justice and to set and learned ASG Sri S.V. Raju, appearing for the petitioners in the other writ petition, would submit that recording of FIR in a cognizable offence is mandatory in view of the law laid down by this court in Lalita Kumari 2014 volume 2 SCC page 1. According to him, when the Honorable Chief Minister and the Director General of Police are involved in the matter, it cannot be expected that the police officers subordinate to them would conduct the investigation in a fair manner. He would submit that the present is a case where the offences committed by the respondents should be investigated by the CBI. He would next submit Sri Kapil Sibal, learned senior counsel, appearing for the respondent number 2 in first writ petition, and Sri Abhishek Manu Singhvi, learned counsel, appearing for the respondent number 1 and 3.
Yeah.
1 and 3 would submit that the present petitions are not maintainable. He would submit that there is a pattern of interference by the ED in the name of investigation exactly at the time when elections are due. They would submit that when the matter is pending in the High Court, the present petition under Article 32 of the Constitution of India may not be entertained. Taking us to the materials on record, particularly the Panchanama available at page 66, it is pointed out that nothing material was recovered during the search and the seizure. It is also argued that the local police officials were not informed by the ED before initiating the search in the morning of 8/1/2026. Sri Sibbal would particularly submit that the respondent number 2 had not gone to the place of incident in the capacity of the Chief Minister, but she, being the chairman of Trinamool Congress, had gone there on information that certain unauthorized persons have entered into the premises of Mr. Pratik Jain, who has been entrusted with party's election work. According to Mr. Sibbal, there was nothing available in the office of I-PAC accept some election related documents with which ED has no concern, and they should not have entered the premises. Full stop. The Sibbal would also submit that the respondent number 2, being the chairman of the TMC West Bengal, it's a national party, by TMC, is a jet protectee, is also a jet protectee. This is your argument. Mr. Singhvi will submit it. Singhvi would submit it. So it is a jet protectee. Therefore, it was the duty of the Director General of Police to accompany her when she entered the premises of Mr. Pratik Jain. Sri Shyam Devan, learned senior counsel, appearing for so and so, or respondent number 4 and 5, would argue that when the that it is factually correct that some untoward incident happened when the High Court proceeded to hear the matter on 9th January, but thereafter, on 14th January, the matter proceeded peacefully but has been adjourned at the request of the ED. Therefore, this court should wait for the outcome of the proceedings pending before the High Court. Having heard learned counsel for both the parties, we are of the prima facie view that the present petition has raised a serious issue relating to the scope of the investigation by the ED or other central agencies and its interference by state agencies. According to us, for adherence of rule of law in the country and to allow each organ to function independently, it is necessary to examine the issue so that the offenders are not allowed to be protected protected under the shield of law enforcing agencies of a particular state. According to us, larger questions are involved, has been raised and are involved in the present matter, which, if allowed to remain undecided, would further worsen the situation, and there will be a situation of lawlessness prevailing in one or the other state, considering that different outfits are governing at different places. True it is that any central agency has no power to interfere with the election work of any party, but at the same time, if the central agencies are acting bona fidely to investigate any serious offense, comma, the question arises as to whether in the shield of taking shield of its party activity, comma, the agencies can obstruct it in carrying out their investigating power in a bona fide manner. Issue notice to the respondents. Let counter affidavit be filed within 3 days. Can you file it within 3 days?
Not possible.
Within a week. Within a week.
It's not that, at least 2 weeks. Maybe minimum 2 weeks.
2 weeks. Then we'll preserve all the material. If it takes longer time, because the digital
Not
evidence.
preserving, Maharaj. Your losses make
Yes.
no issue on that.
Yes,
Uh,
in 2 weeks.
2 weeks.
Post the matter on. Today's 15th. Post the matter on 3rd February.
Lord, prayer A and E.
Full stop, full stop. In the meanwhile, it is directed that the respondents shall preserve the CCTV cameras and other storage devices containing the footage of both the premises searched on 8/1/26 as described in the writ petition, and the CCTV cameras and storage devices containing the footage of nearby areas. Now, what it is to this investigation? And the CCTV 8/1/26 full stop. It is also directed that the further proceedings and the investigation relating to FIR number 3/26, 4/26 and 5/26 registered at electronic.
There is one more, 7 also, Lord. I have placed on record.
It is there in the main petition, but not here.
In the additional document, it was filed
7/26 registered at electronic PS, Vidhan Nagar.
No, there are 2 from Shakespeare Sarni.
Just name the police station properly.
No, it's in E. E has, my lord, the police station, page 126E. 2 are, my lord, from Shakespeare's Sarni, and 2 are from electronic PS Vidhan Nagar. The index, my lord, in the present.
In this IA.
Yes,
Direct.
it's a document compilation.
Is also direct that FIR number 3/26 and FIR number 4/26 registered at police station Shakespeare Sarani, and FIR number 5/26 and 7/26 registered at Electronics Complex PS shall remain state till the next date of hearing.
Or any other FIR pertaining to this?
We may not be aware of.
This is
We
not
do not
a
know.
blanket order.
There should be clarity in our order.
Yes,
You
sir.
can't say that any other this
No, I understand.
is not proper.
Great.
Whereas I have one request for you, just Lordship considering. Whereas normally a Lordship does not stay investigation. No coercive steps will be taken is an alternative.
No. You see, in view of section 67, if they were armed with a letter of authorization, they were acting in good faith.
So I'm only saying, investigation without any coercive steps.
Mr. Singhvi, you understand the delicacy of the matter.
But equally,
If you
both sides.
proceed with the investigation in any manner,
Without
then it will be
any
difficult.
coercive
But
steps.
then we will.
Without any coercive steps.
No, my lord,
In
I
any manner.
that may not.
Secondly, if your Lordship is granting a stay on investigation, then let us have more time to reply, because then there will be a complete stay on investigation. Let us take out all.
No. 15
There has
days
to
is
be
enough.
more.
What more you want?
Maybe 3
In
weeks
fact, this
before.
order could have been passed after 10 minutes of hearing. We indicated to you that we are inclined to issue notice. But since both the parties have raised that much of argument, it is necessary for us to record also.
Yes,
Because
be a little
nowadays it is aired, everything.
now
And
that
then
it is,
everybody will say that court has
now
not
that it is
recorded anything,
stayed,
so much was argued.
now that Lordship has stated, little more time can be given. That's
Yes, next case.
My lord, the IA for addition of party, Chief Secretary and others are being joined. And my lord, prayer for
Chief Secretary.
suspension. No, suspension power is with the Chief
No,
Secretary.
that's suspension.
That's my prayer. That's my prayer.
We file a counter.
That's my prayer, my lord.
Let's
strongly opposing this kind of.
Notice may be issued.
let counter to IA number so and so
Yes,
may also be filed.
yes, yes.
It's not even listed, Malad. It's not even listed.
No, it's given, my lord. Copy is given to them. I have tendered
These
it.
are the strange
You
procedure.
kindly list it tomorrow, my lord.
Whatever
Let
it
them
is.
file a reply. I may not get the relief today.
Just not.
You only file counter. We are not saying anything. No passing
Yes.
no orders on that.
We'll file.
Passing no orders on that.
Malad, if we filing counters in applications, then the main matter, Malad,
There are only two main matters.
There's so many matters there.
No, only one matter in application.
Let's
That's all.
let counter to IA number so and so. Which are those IAs?
We'll give the number.
It's not
We
numbered.
file before the next date of hearing.
Yes.
Yes, next.
Item 28.
Right.
हमारे notes का इस production है.
22. Corrected.